Before I talk to you about domestic violence and domestic violence protective orders, I'd like to talk about a separate animal. 3 years ago, I learned that there was a case called Riffle against Ware, I think it might have been. Harrison County Circuit Court ruled that the family court was not able to order a woman who was harassing her dying former husband, who had leukemia, with constant pleas to take her back and to reconcile, and just things that were driving him to distraction and probably endangering his health. But it was ruled that the family court was a court of statute, and that right had not been granted, that unless there were allegations of domestic violence and the domestic violence statute was invoked, you couldn't do it. I complained about that on Facebook, saying Supreme Court says family courts can't make people in their courts behave. And my friend Tom O'Neill, who was then counsel for the State Senate Judiciary Committee, chaired by Charles Trump, our senator, Republican senator, he reached out and said, why don't we write a law on that? So I did. I drafted the statute, whereas blah, blah, whereas blah, blah. When you look at the final version, 10 drafts later, they're very clearly based on the same concepts. It actually got a little stronger by the end so that the court could pretty much enter these orders, even in my opinion, at the beginning of every case. I haven't found any judges that I know of that issues a West Virginia Code 51-2, capital A, 2, small a, restraining order against bad behavior at the beginning of the case. But I think it makes a good that is a good idea. The reason I say that is, why not order people not to post on Facebook? Why not order people not to talk about their case in front of their children? But that's for another day. I'm proud of the statute. It eventually got passed. It got through both committees, both judiciary committees, without a negative vote. We had to go down and lobby for it and reassure the folks that were afraid it was going to interfere with funding in the Women's Against Violence Act and the Domestic Violence Statute. We got through that, West Virginia Legal Aid, an old Sunday school, an MYF mate of mine, I won't mention his name, was kind enough to lean in favor of it at the very end, and we ended up, by the day, I left about 11 p.m., and by the next morning we had a even better, a slightly tighter, more unambiguous law than we had before. So I'm real proud of that. I'm also proud that I had recommended, when the California anti-stalking law came into place over 20 years ago, that my good friend Dale Riggs took that statute, which I had to try to, you couldn't just get online and find it, but I did get a copy of it, gave it to Dale. He went down, and it turned out, I learned this in my personal meeting with Senator Trump 3 years ago, that he and Dale Riggs had been the ones to soothe the worries of the labor unions and other people who thought it might be used against them, to get a stalking bill that primarily was there to protect women from unwanted harassment and stalking and threats. I will never know who, if anyone, those two laws have saved or protected, but I'm proud of them, and I hope they're part of my legacy when I am ready to hang things up.